Hello everyone, I am Sergio Maldonado and this is Masters of Privacy, a set of interviews covering the intersection of marketing, data, privacy and technology with a clear goal in mind, which is redefining the relationship between people, brands and media around transparency and control. Which is to say, we're aiming for real customer centricity, or if you will, human centricity. We regularly talk to DPOs, CMOs, CDOs, and whoever else we find interesting and able to share valuable insights. So we hope you like it. Please do reach out if you have any ideas on future topics or speakers. Okay, we've got Peter Craddock here once again. There's been some developments in the past few months since we spoke in February, and we're going to revisit the ePrivacy Directive, advertising, analytics, the limits of consent, Meta not being able to emulate publishers in the use of consent or pay prompts, and server-side processing. As for Peter Craddock, he is a lawyer as well as a software developer. He's based in Brussels and helps international companies with their global data strategy and with EU data litigation. Peter has strong expertise in the legal aspects of digital advertising and ad tech. Let's go for this second round with him. Peter, thanks for coming back.
Thanks for having me again.
Since we last spoke, a few things happened. So the guidelines on the scope of Article 5.3 of the ePrivacy Directive have been adopted. What else happened? Google decided to keep third-party cookies in the summer. Then Spain issued the guidelines on analytical cookies, saying that there was a way for them not to require consent, which opens up a few possibilities. And then a big one, there was the opinion on consent or pay. And the EDPB made it clear that it would apply to, or made an effort to limit its conclusions to large online platforms.
Yeah.
Okay, so that's all happened in a few months. And now that we've got the adopted guidelines, there hasn't been any change. I've read your posts. So they haven't listened to anybody, I guess.
There have been some small modifications, but from a substantive perspective, they're not really modifications as such.
Yeah. Okay, so something where you and I left it is that there is room for us to explore the exceptions, and the guidelines are very expressly leaving that out. They're not dealing with exceptions. And you were saying the strict necessity, since we're adapting everything to the new times, and we're saying, okay, so everything that you are doing on local storage or APIs on the browser side, that amounts to storing and accessing, then why not update what used to be reserved for session, for us to keep a shopping cart alive, or for us to keep a user authenticated, or a language pre-selected. Those were very limited scenarios that we could foresee back in 2009 or before that, 2002. So we could expand that, and I want to go back to the idea that if we were to use that, we are accepting that there is room for a risk-based approach instead of a binary consent requirement for everything. So have you had any further thoughts on whether we can apply the legitimate interest test or a risk-based approach to how we are, again, going around, how we could maybe leverage that exception?
So the consent exceptions that are there, and in particular then the service one, because that is the key one that allows some flexibility. The way it's worded is that there is no consent required under Article 5.3 of the ePrivacy Directive if I basically need that operation of storage, or I need to gain access to information already stored on the user's terminal equipment, if that's strictly necessary to the provision of information society service, so basically a digital service that is explicitly requested by the user. Now, the way this is worded, it's about the provision of a service to the user. Now, regulators are often focusing on the aspect of delivery of the service. And so they're thinking purely about kind of the last mile. So I've got my content, I've got my service, I've got my hosting, I've got everything in the backend, everything is already there. And then it's just the actual technical delivery to the user. That is what they're focusing on. But when you think about the notion of provision, I can't provide a service if I don't have it to start with, if it's not available. And so I think the word provision needs to be interpreted in the way that it actually is meant, and that is broader than purely the last mile delivery. It's not just that technical delivery, it's much more than that. And you see that in the way that exceptions were interpreted already 10 years ago. Because already back in the day, we're not talking about dinosaur ages, this is 10 years ago. 10 years ago, it was already accepted that security could be strictly necessary. So the Article 29 Working Party, the predecessor to the European Data Protection Board, had said that security measures can actually be strictly necessary for the provision of the information society service, so the digital service. Now, security is, in that context, is about protecting the service. It's about protecting the service provider. It's not necessarily about protecting the user. So it's actually protecting me as a service provider against malicious users, against attacks. It's about validation so that I can do some kind of checks that I'm not basically being defrauded by the user. That is not at all beneficial to the user. It is beneficial solely to the service provider. It has nothing to do with the actual positive technical delivery to the user. It's about even blocking certain kinds of provision. So I think this shows the fact that provision has to be interpreted in a broader manner. Now, if you accept that security measures can be relevant to the provision of the service, then for me, there's then a bit of a conceptual distinction that is being made artificially between that and, for instance, anything that has to do with funding, because monetization is inherently required in order for me to provide a service. Whether I am a non-profit or a for-profit, my service is supported somehow. It's supported by people who are investing their time, by people investing money, and there's funding behind it. You can't operate for free, full stop. And even if you are talking about a collective of individuals, they're also investing their time in something. So there's always something that is necessary in order to lead to the provision of a service. And when we interpret that notion very restrictively, you're basically cutting out monetization completely and then saying, well, no, security is allowed, but monetization isn't. What is the justification for that? Now you have to then try to figure out, well, how far do you go? Because analytics have been accepted in a number of cases. You were mentioning the Spanish example. Well, we've had now a decade of evolutions. We've had France, we've had the Netherlands, and then most recently Spain. We had some hints as well in Italy. And so you have a number of countries where regulators have said, actually, it's okay. If certain conditions are met, we consider that this can be strictly necessary to the provision of an information society service, even though the actual technical delivery has nothing to do with analysis of performance. This is all for the benefit of the service provider and of the following user. It's not for the benefit of that user. So regulators seem to be, I don't want to say schizophrenic, but it is that they seem to be applying a double standard. That when they want, then they can say something is actually strictly necessary to the provision of the information society service. And then when they're not too keen on it, they're saying, no, we have to focus purely on the user's perspective, like the ICO in the UK has been saying, or we want to focus purely on the technical delivery, which again doesn't make sense if you think about some of the exceptions that have been recognized previously. So I think there is scope. The wording of the law allows it. The wording of the law is flexible, and we have to think about the ordinary meaning of the words. And when you think about the idea of provision of a service, provision is an overall aspect. It's not purely that technical delivery. Otherwise, it would have been much simpler for the legislator to just say solely for the delivery of the service. It's not delivery, it's provision, which is a much broader term. And again, it's not the technical delivery, it's the entire provision itself. And provision includes then the making available of content in the to start with, for instance. So I think we have to have this broader approach to the notion. And the exceptions in the past suggested there was room for that. Regulators have been trying to narrow it down as much as possible. But the ePrivacy Directive is still here to stay. We don't have an ePrivacy regulation, so we do have to make do with the legislation that we've got. And the only way to make it work is to have a teleological approach, an interpretation that makes sense, where we look at the meaning and we look at the way they should be applied today. And to me, a broad interpretation of these exceptions, one that encompasses the actual meaning of the words and the logic behind the ePrivacy Directive, makes sense, because the ePrivacy Directive wasn't there, or this particular provision of the ePrivacy Directive is there to help fight against things like spyware. It's not there to destroy business models. That is not the intent that the legislature put forward when they were drafting the recitals for these provisions, to explain them. The recitals of the ePrivacy Directive relating to these rules, they talk about cookies, they talk about spyware, they talk about tracking basically in a way that is hidden to the user. This is not about preventing me from improving my service. It's not about preventing me from monetizing my service. That is not the intent of the legislator. And so I think we do have to always take into account the initial intent of the legislator, and it isn't to knock down business models, it's to allow them, but to prevent certain misuses. And that is what we should be going after.
Very good. But maybe we don't need to go all the way back to what's needed for the business to exist, meaning to the fact that we need advertising for a publisher to exist. But even the very fact that instead of having a shopping cart, right? So we need sessions to work and a computer browser to retain, to remember that you've got some items in the cart if it's an e-commerce site. If it's a publication and it makes a living on advertising, I would not question in business models because it's not the role of the ePrivacy Directive, as we're saying, then why do we need to go all the way back? Perhaps the very fact that it is running on advertising means that for advertising to work, as I believe you've said in the past, we already need certain things, as an exception, meaning the website runs on ads, the ads need to work, therefore there's a technical necessity. Mm-hmm. And then since you're opening you're talking about analytics, I think that opens up a very interesting debate, and that's what I wanted to get with this, which is if we are accepting that analytics, which is not even core to the provision of a service, although we could accept that by looking at what's happening on the website, we know what content is more popular, therefore we know where to invest, plus everything we can do when we're making data-driven decisions. But by opening that up, we're also accepting that there's a risk level approach. That's my point. So that we are now opening up the possibility that everything is not black and white. So that if people want to do analytics and then they respect the list of conditions, as you were saying, Dick Neal, initially published that list saying, well, 13 months, that's the lifespan of a cookie that then Spain copied, same lifespan, 25-month, history or data retention. All of these conditions are attached to something that will not require consent, even though it is not clearly exempt from the text of the privacy directive. And I'm after privacy preserving technologies that have been discarded because of these guidelines. Again, because now everything requires consent, so it makes no sense for publishers to explore topics API or privacy preserving, retargeting. There was a recent study by Boston University showing that retargeting could be done in a very privacy preserving way, but who is going to try this now if you require the same consent that you require from the retargeting we've been doing all along based on third-party cookies?
This is actually what I'm seeing now, literally in litigation cases. I have one case where someone has filed a complaint against a provider that basically does their key product is a privacy enhancing technology for analytics. And there's a complaint against them based on the ePrivacy rules. And so if this is the kind of thing that we're going to be facing more and more often, then who is going to invest in privacy enhancing technologies? Because if the idea is you need consent for this because it's covered by the ePrivacy rules, first, again, I'm not convinced that is actually the intention of the legislator, but even if it was, then we'd need to figure out a way to interpret the service exemption in a way that covers this, that allows those measures, those privacy enhancing technologies to be used without consent, because otherwise, indeed, who is going to go for that? If you need consent anyway, why not go for more? Why not get more data? Why not get much more intrusive tracking? Because anyway, I need consent.
Yeah, yeah.
And I like to use an analogy, which is the one of language preferences. Because when I go on a website that is multilingual, I, as a user, have no intention of making the same linguistic choice every single time. I expect the website to remember it. But that is not how regulators have been looking at this. There has been guidance from certain jurisdictions that has said, no, it has to be limited to sessions. Otherwise, you require consent. I mean, if you're going to focus on the user's perspective, seriously, take into account the user's actual perspective. And their perspective is, I expect this to be remembered. I do not want to have to make that choice again. And so I think regulators need to adopt a much broader view of what is actually the expectation then. If they're going to focus on user expectations, they have to understand what those expectations are. And those are not necessarily as strict as the hawks among us would like it to be. So I think we do have to take into account the fact that normal internet users do expect certain things to be remembered. And maybe there's a question of which level of information should be provided in addition. But it's not a question of saying, well, then you need to provide consent in any other situation, because that just doesn't work. And this is not how users expect things to work. So they are explicitly requesting something. They want a language change. Why shouldn't we be able to remember that? So that is one illustration, I think, of the most basic understanding of what is a service. But I think you do have to take into account the fact that when you apply a broader interpretation, you allow certain solutions to exist, whose precise existence, whose purpose is precisely to enhance the protection of individuals.
Yes, that's what I'm after. If we could, we are turning our backs on data minimization, on privacy by design, because we're avoiding, we're not paying attention to the nuances. So imagine that we were to apply the same logic that we've applied to analytics in these jurisdictions that you're mentioning to advertising. So we could say we need advertising, then because it is going to collide with a fundamental right, there's certain risks. We could already say, okay, special categories of data about children, they're out, or they do require, these conditions. And then for everything else, we can look at different degrees, and that would open the door to even user preferences, in the sense that if I can, within my device, control the topics that I'm exposing, the interests that I have, and I can have a cross-site interest that I'm sharing, and it's saving me time, because the ads that I see on YouTube do not touch my health record, do not touch data about children, but are actually relevant. There's a lot of people that do want that, as long as they're in control, because you know why you're getting this ad in your
Hmm.
YouTube videos. So there's an element of control, there's an element of a privacy or data minimization, to be very specific, in the sense that you only keep whatever is needed for that. But that's not allowed because everything requires consent. So because it does, then we've seen publishers using consent or pay. Then we've
Hmm.
seen Meta using consent or pay. I don't want to open the whole consent or pay debate. You've been already very active in that debate. So I simply want to say there's a clear inconsistency, and the way that inconsistency between how we treat publishers, media, and how we treat a Meta has been this element that is very clear, which is that in Meta you have no choice, in the sense that your data is there. You have no way around your Instagram social graph. You are tied to it. You cannot go anywhere else for that graph. Whereas when you go to a newspaper and they're asking you to consent or pay, you could go to another one. Of course, then they will all agree to release their consent or pay paywalls at the same time on the same day, as it happened in Spain. But in theory, that's a theory. So you've got that justification. But we are now pushing or throwing the problem at the definition of consent, and we already had this chat, you and I, last time. So
Hmm.
is this free consent? And we are now agreeing that, or I'm not agreeing, but what I'm reading is that the supervisory authorities accept that they will have to be flexible with the definition of free consent, because there's a higher social value, and I want to get to that. So journalism has to be protected. There needs to be, again, it's a key pillar of democracy, unlike Meta. So we need to give them, they need to make a living. Therefore, let's carve out an exception for them. No one is saying this literally, but that's what's happening. So how do you see this evolving? They're saying they're going to come up with new guidelines for consent or pay. So do you think this is going to be able to resist much more a different treatment between large online platforms and online publishers?
Well, it's interesting that you say that certain large online platforms might not be as essential to democracy, because actually the European Data Protection Board is suggesting that they are, in their explanation of why they think that these large online platforms, which is a very vague concept, and I'll get back to that. They're basically saying, well, one of the reasons why consent is not freely given is because they have been so essential, because you cannot live without them. So, because you go there to find information, to stay in contact. So basically, they're saying this, they're part of the fabric of our daily lives, and we can't get rid of them. Well, fantastic. Then why precisely should they be treated any less favorably then? So I think there's a big question there, that is the end justifying the means? Is this one of those cases where the documentation that is being produced by regulators is actually produced with a particular aim to start with, that is tainting the entire reasoning? They've already reached their conclusion before they started drafting this. At least that's my opinion. But I think it's a relevant issue, because when we talk about large online platforms, which is an undefined concept, you then think about, well, what does that cover? And if you look at the inspiration for this term, the key inspiration seems to be the idea of the very large online platforms and the definition of a platform in the Digital Services Act. Now, the Digital Services Act defines platforms in a way that actually covers a lot of media organizations and their publications that I know of, because it's basically about, to simplify it, it's about the idea of a community, that I go somewhere because there is an audience that I will be interacting with, whether it's because I'm selling and I want to reach certain people, or because I'm trying to socialize and I'm trying to reach certain people, or because I'm interacting with news articles and there happens to be a very strong community around a particular news platform, which is the case on a number of publishing websites. There are some publishing websites that are known for the fact that you don't just go there for the content, you go for the comments as well. So then suddenly, because someone happens to have a significant number of users in the EU, then suddenly they are a large online platform within the meaning of the consent or pay opinion of the EDPB, has this large online platform notion. And so it is basically suggesting that the moment you have some kind of community building exercise, actually you fall under the scope of this notion. So because you are rewarded for the fact that you built a community around your product, well, then suddenly actually you are subject to additional rules, which isn't really a very nice reward if you think about the consequences attached to it, because suddenly your consent is never freely given if you read the EDPB opinion on consent or pay. So I think the approach is tainted by this idea of we need to reach a conclusion. We don't want to say that it's one platform, but we're going to use wording that covers them, and then to hell with the consequences for everyone else. The guidelines that are going to come up are going to be an interesting exercise. There's the stakeholder event that's taking place in 2 weeks' time, so I'm glad that they've accepted that I could be present. But this is going to be one of those more semi-consultation things where they're going to try to get some feedback before they start working on the guidelines. And it will be a delicate balancing exercise, because we know that the conclusion is likely going to be a bit tilted towards something else, because suddenly there'll be much more national interests also in play, because of the fact that suddenly it's not about certain US-based organizations, but it's about large EU-based publishers. And then suddenly the challenge is different. So I think it will be a very interesting balancing exercise for the European Data Protection Board to come up with guidelines that contain legal arguments to support their position, why something should be different in the case of a large online platform and why it should be different in the case of something that isn't a large online platform. The reasoning of influence on democratic process and on society, I think, is a very subjective one. I have certain news websites that I visit on a daily basis that are critical to my life. I have certain social media websites that I'm very active on, notably from a professional perspective, that are very important to my daily life as well and my professional capacity. Why is one treated differently compared to another? I don't know. I really don't know, because I haven't seen a legal justification for that so far. So I think it will be an interesting exercise to see what the European Data Protection Board comes up with. But to protect, just particularly, specifically with respect to the point that we were discussing also regarding consent, the interesting thing in all of this debate is that these are two different realms, the ePrivacy Directive, the GDPR. The problem is, it all comes down to the GDPR notion of consent. And I think we do have to bear in mind the fact that consent doesn't have the meaning that regulators suggest that it always has. Consent can be combined with other legal grounds. We have Article 7.4 of the GDPR that I like to reference, that is very important in a number of cases. That means that basically the freely given nature of consent depends on the context. And there are cases where I'm going to be required to have consent because, for instance, the European Data Protection Board might not want to have a broad interpretation of the notion of consent of the consent exemption. And so then I need to have consent under ePrivacy rules. Well, then maybe that consent is not the same, is not freely given in the same manner as, for instance, when you talk about employee consent, where the context is vastly different. So I think we do have to bear in mind context when it comes to assessing the freely given nature of consent.
Yeah, okay. So to break it down, I think we do need some honesty. There's probably a political agenda when it comes to Meta. Something that is annoying to me as well is that, and I understand how regulators see that, how publishers influence them to see it this way, they're not producing any content of their own, and they're sort of living off the rents of having digitized our social relationships one day, right? In a pretty aggressive way, in the sense that we, at some point, we're all incentivized to sharing, to connecting to offloading our contacts, our agendas, our social connections, even those that had never been digitized. It was the first time that you digitize your offline, network. So it happens once. You're not going to do it again. You do it once. And I do understand if there is a concern that someone is just, living off the rent of having done this very well in a very aggressive way, even provoking or incentivizing people to share beyond what they were probably aware back in the day. So what happened with Facebook back then, with Instagram, again, living off Facebook and Twitter when it started. But why do we need to let that anger or that frustration transpire and affect everything else we do? If we had a clear debate about that, maybe we could have a very clean debate about this.
Well, I think there's an interesting angle whenever the issue of certain US-based platforms comes up, is that some of the regulators are very proud to say they don't have an account on this or that social media platform. So apparently it is possible to live without them first. Second, it's interesting to see that this is very much a question of demographics. And if you talk to some people who are a bit younger than ourselves, that actually the platforms they talk about are completely different. And so yes, they are competitors. They are competitors, just that sometimes some of us are too focused on one or another. Just because it is dominant in my personal life doesn't mean that it's dominant in my neighbor's personal life. And so I think we do have to be very careful when we're making assessments of the importance of particular platforms, that we take into account the fact that for some people, they just don't exist. They don't care about those platforms at all. Just to illustrate, I know that with the evolutions on the side of, for instance, X, there had been suddenly a large saying, we're going to go, lots of people are going to go to Blue Sky, to Mastodon and so on. And some of these communities are really thriving. Some of them are dead, some of them are thriving. So it depends on your context. You have some situations where you are going to be saying, this platform is really important to me because of my connections. Some of the time, I am going to move with my connections and it's going to work. Maybe it's a question of effort. But so I think it's really important to put some kind of nuance in this discussion, that there's potentially a bit of a focus on certain platforms that historically might have happened. Maybe we should actually be moving away from the discussion regarding one or two platforms and starting to think about objective factors that have nothing to do with one platform or another, but really trying to get to the essence of the legal arguments, which is No, what are the conditions for freely given consent? What are the conditions under which the contract legal ground can be used under the EPR? Under which circumstances can the service exemption be used under the ePrivacy Directive? And I think there's a lot of merit to having discussions on the very objective factors that have nothing to do with the size of a platform or its importance in my subjective situation. And I think if we move away from that subjective element, we could really get to a lot more interesting debates, I think.
Very good. Okay, so now let's assume that, again, consent is a mess, or many of us will not like how consent has become, blackmailing, and then we want to move away from consent. So we want to have something that, I guess the easy way is go around the ePrivacy Directive. So that means let's not use anything that happens on the device. And the easy one is let's go server to server. And that opens another avenue. And there's plenty of people doing things server to server. For a long time, we had server to server or server-side analytics. But now on server to server advertising, if we need to first plan, so look at the audiences that we're going to target, then targeting, and then measure or have some attribution, then server to server has been enabled through a couple of things that I see growing a lot. So one of them is on the large platforms side, not just Meta, so TikTok, Amazon, Google, of course. They all have some sort of conversion API or enhanced, tracking, enhanced conversion, whatever you call it, an events API where advertisers can upload success events up to the platform so that they can then see what worked and so on. So the optimization loop keeps on spinning, or the wheel keeps on spinning. So how do you see that? The conversion APIs, do you get lots of people coming and asking? And also, what do we do with that? Because you're uploading data. Someone has to decide what kind of data you're uploading. And there's got to be some sort of risk-based approach as well.
Well, a lot of these measures are there precisely also as privacy enhancing technologies. And what I've been seeing in the work that I've been doing in that respect is that a lot of the time this is precisely built in a way to have some kind of segmentation, that we're going to limit the information available to one party by basically getting different kind of levels of filtering basically along the road. And so that server to server approach is one where you're going to try to choose which kinds of information are being made available. And then you're going to try to do some kind of matching in the end of the, to simplify basically the input and the output in the context of conversions and of events basically that suggest that there has been, that someone has seen an advert, has interacted with it, or has seen a piece of content and has interacted with it. Now, the way that this happens is around, I don't want to say obscurity, but it's basically about kind of masking certain bits of information. So there's no longer a kind of direct route to the visible approach of, this person has actually ended up buying this product. Now, if you apply the interpretation of the European Data Protection Board regarding storage is interpreted by the European Data Protection Board in its guidelines as basically meaning any information that is going to be included even in computer memory. So we're talking about RAM, we're talking about CPU caches even in the guidelines. So this is a whole range of computer processing activities. Now, I mean processing in the computing sense, not in the GDPR sense. These are operations at a computer level that happen all the time. If I visit a website, I get a copy of information regarding the structure of that website on my computer or on my mobile phone. There's a copy that is being created within my runtime environment of my browser. that is going to be stored from a purely ephemeral perspective. It's very temporary on my device. It's being kept there so that if I put my computer to sleep and then wake it up again, I still see it. There's information that's being stored on my device if you use that interpretation of storage. But it's never the intention to keep that so I can retrieve it later. The idea is this is about, a very limited period of time. This is about allowing me to basically have that functionality to start with. So if you consider that to be storage, then every single interaction with a computer is storage, because it is always going to be processing of information. So basically, my user interface that I'm seeing of this website is stored on my device. So then, do I suddenly need consent to see a user interface because that is being stored on my device? Some people like to have clean, pure text interfaces. So then they could say, well, this is not strictly necessary to the provision of the service. So then actually, no, there should be consent for providing a UI. It doesn't make sense. It doesn't make sense. And so that storage interpretation, I think, is way too wide. You can't have that because in computing terms, you always make a distinction between storage and memory. It's like that. It's inherent. It's in the way that things are perceived from a software and a hardware perspective. It's baked into computing. And so you can't suddenly say, well, actually, no, we're going to interpret in a way that we think, because it just doesn't match with the reality. So that is one thing. So let's move on to the server-to-server discussion from there, because then server-to-server means that there is a request being sent by one server, by one device to another one. Now, if we're then saying there's a computer involved, we know there's storage of information. So actually there is storage within the meaning of Article 5.3 according to the EDPB. So then suddenly there's a question, well, is it a user's terminal equipment? Is it the terminal equipment of a user? Actually, in the case of server to server, it isn't. But this is where the gaining of access loophole comes in, because the EDPB interprets gaining of access as not only meaning I'm gaining access to information on the device of the user, but also I'm gaining access because I'm receiving information automatically. So as soon as a user's device connects to a server, by virtue of the way that the internet works, there's automatically some information that's being transmitted. It's just the way that the TCP/IP protocol is meant. That's how it works. So there's, for every single internet communication, there's information that's being sent by my device through a server. That server then, according to the EDPB, is receiving that information automatically, yes, but they see it as gaining access. But if it's gaining access for the first server along the road, then why should it not be gaining access for the second one along the road? Because ultimately it is information that is received automatically, but with an intermediary along the roadway. So then if you interpret the rules according to the EDPB's interpretation, server to server would also require consent, even though there's no user involved at all. And the user has no interaction with the second server.
Yeah, but because the signal originated in the device, because ePrivacy is about protecting the device, and the signal originated there. So then we need to make a distinction, because sometimes there's conversion APIs that will upload offline events, and then it gets even more nuanced. So I get your point. The definition is so broad, and these guidelines are so out of control that in the end, in theory, everything could require consent. And, something that we won't have time to cover, but I was also thinking there's another way to deal with, to escape the privacy directive, the lex specialis, and just aim for the GDPR and hopefully for legitimate interests or the contractual legal basis, which was this collaboration happening in the other world, not the large platforms, but mostly retail media and more of the open market with data clean rooms and data collaboration and how people are sharing with trusted execution environments or different pets, different privacy enhancing technologies. But in the end, I'm eager to explore something that I have seen, and in fact, in one of your recent debates, I heard this, and I thought it was very telling, or a confirmation of something I've been thinking for a long time, is that only the large platforms can really work with the levels of acceptance, with the levels of consent, with consent rates that are being, that result from increased enforcement of valid consent, of reject all on first layer. All of these enforcement actions are having an impact on consent rates. And I can see that a Meta and a Google can both work with their gigantic, vast amounts of first-party data to model the data they do not have, and then simply add as a nice to have, granular data, which is, based on on consented devices. Whereas smaller platforms, advertisers, they do not have the luxury. Something that called my attention was this idea that when people are presented with consent or pay, many will consent, but many others will walk out and they'll vote with their feet by simply abandoning the site, and that in total you may get just above 50% of acceptance, even with a consent or pay. Those numbers for many of the things that we are trying to do are not enough if you do not have enough volumes. For example, A/B testing. You're expecting to have some significance for A/B testing. So how do you see that? We need to escape. Consent is not going to work for a lot of people. It's going to work for the larger platforms. So how are people finding a way or a working path towards legitimate interest or the contractual legal basis?
So, but this is where a lot of the aspects of the consent or pay debate focus too much, I think, on the pay aspect. Because ultimately what the European Data Protection Board is saying in its consent or pay opinion is any situation where you are using behavioral advertising, profile-based advertising is bad, and you need to have an alternative. It doesn't matter whether you have a paying option or not. What they're saying is you need to have this free alternative without behavioral advertising, basically contextual ads or general advertising, however, whatever that means. But they're basically suggesting that if you're using profile-based advertising, you need to offer another option. Now, if we ignore that idea of the European Data Protection Board and we just focus on consent versus pay, basically the idea of subscribe or accept ads, the numbers are indeed not as North Korean as some activists have suggested. They're basically, the numbers reveal that the percentage of people who are going to choose to consent versus paying can vary, can be somewhere between, those who are paying could be somewhere between 10 and 30%, depending on the figures. And so there, indeed, there was some interesting data that had been provided during a recent webinar by Didomi, saying that these are the numbers that they've been seeing in the websites that have been, the platforms that have been implementing a consent or pay approach. But you do have people who might be going somewhere else. The problem is there's also one part of the discussion that is being ignored, and that's people who are using ad blockers. Because if you're using an ad blocker, you're actually not consenting and you're still expecting to consume, to benefit from the service without paying or without consenting ultimately. So that is part of this dark traffic that is often mentioned that you do have to take into account as well in your assessment from an economic perspective, and that is completely ignored by regulators so far. Some of it because some of them are promoting ad blockers occasionally, but so this is a broader debate regarding the economics and the viability of different options from a business perspective. Now, if you are in a situation where you are faced with that choice as a platform, as a publisher, you say, I'm going to offer people a choice, then you seriously have to think about that beforehand. You have to do your homework, because otherwise it could be economically devastating to you. But secondly, you do indeed have to take into account the competition. You have to think about, if people are going to walk out, where are they going to walk out to? And the point you were making earlier about the fact that, yes, in Spain at one point, a lot of the bigger media organizations rolled out a similar approach at the same
On
time.
this same day, yes.
Yeah, on the same day. Well, this was a point of, looking at each other and trying to figure out, well, what is someone else going to do? And if you do that smartly, you ensure that you are going to be able to avoid a significant run out of your customer base. So there's some economic sense behind this that I think should not be ignored. But the consent rates are not necessarily that bad. They're not we're not talking about 99% of people who are accepting consent, and then less than 1% are accepting to pay. It can be economically interesting to go down that route of offering the two choices. The question then is going to always be, well, what is the price that I'm asking for? Is it going to be abusive? If I'm somebody going to ask for 120 euros a month as opposed to 5, obviously this has a significant impact on whether people are willing to pay for that access or not. But these are, in my view, discussions that have nothing to do with the GDPR. These are competition issues. And so I think this is one of those areas where the impact of the GDPR from an economic perspective is one that really requires a broader approach by lawyers, by regulators, about how are we going to deal with this? In-house counsel, DPOs, they really have to think about these broader economic considerations before they get into any debate internally about whether they want to be pushing for one option or another.
You're right. So competition is a big one, and when I talk to publishers, and I've been dealing with a few of the the larger publishers, and it's the ads teams that are behind consent or pay. They're not after subscriptions. They know that in the end, all they want to do is get consent rates to be higher.
Mm-hmm.
So when that is the case, then my question is: now we're going to move beyond what happened with Chrome and Google keeping third-party cookies. And what Google said they're going to do now is they're going to have, I think they call it elevated user choice.
Yeah.
That's the new thing. And the speculation, it could be like ATT in Apple devices, so side by side. And most likely there'll be a single cross-site prompt whenever you install the browser. So maybe closer to the global privacy control that we have now, the signal that is spreading throughout the US, for example, right, as an obligation by like state privacy laws. So if you have something like that, like a global privacy control, which means that we finally get rid of the of consent management platforms and pop-ups, because you can do it once across the board and it applies to every single website, then publishers are going to have to adapt. And that's where I'm hoping that we can rely on legitimate interest, that we can apply a risk-based approach, and that finally we make a distinction. If somebody thinks, or any authorities think, that some advertising techniques are too risky, that we finally open the door to other solutions, like, for example, Topics API or an enhanced version of Topics API, or any other things that could come, like, these private audiences, protected audiences. There's a million different alternatives out there, but we're not exploring them, and they are more privacy preserving. And we're not doing it because publishers have limited resources. They just simply, it's a big struggle for them to adapt. So if they can keep using third-party cookies, they'll do it forever. And they need to be incentivized as well. But you're right, it's a competition issue. And if we were to lay on the table all of the protected sort of social values that we want to have journalism, we want to have competition, we want to protect individuals. And if we were to do all of that, there's got to be a path towards applying the same GDPR principles, the very same principles, to what now is covered by the ePrivacy Directive, do you have any hope that maybe through these external factors, again, Google Chrome, global privacy control, that eventually we just evolve beyond consent or pay and beyond all of these struggles?
Well, I think before we get to some kind of evolution beyond that, we have to bear in mind the fact that regulators are unaware of the fact that they're actually causing significant costs, because in some publishers, they just didn't have a subscription team to start with. And now suddenly they're forced to, by regulators, they're forced to think about how do I integrate in my cost structure, which is potentially already under severe pressure, the fact that now I also have to support a pay option, which I potentially had never really thought about putting in place, or because I discarded it because the cost was prohibitive or something like that. And suddenly I'm actually having to put this in place. So there's a cost element that is really important, an economic one that never gets discussed in these regulatory discussions. But then let's move on from that. So we've got some costs that we have to make suddenly because the regulators are imposing that. We are faced with the fact that the service exemption is being interpreted extremely restrictively by regulators. So then under the ePrivacy rules, I actually need consent for everything. And then we have the fact that yes, there are certain measures that are being provided, certain ideas regarding global kinds of controls, like the global privacy control, like these evolutions regarding certain platforms. But at the same time, the EDPB is saying, well, you have to have a very clear level of information about the identity of every single controller along the chain. You also need to understand the consequences of giving consent, which is something that they've been highlighting in their consent or pay opinion. So the regulators are actually imposing or continuously new and additional levels of restrictions for your consent to be valid, for your information to be valid under the transparency requirements under the GDPR. And so suddenly it becomes more and more complex to do anything. You can't rely on legitimate interest because actually you can't rely on the service exemption under the ePrivacy Directive. So you need to use consent anyway. You can't rely on consent because you need to provide an additional level of information for that consent to be valid. You can't rely on contract because we're going to interpret the Bundeskartellamt judgment in a way that just contract is never possible in any circumstances. So regulators first have to figure out, well, what is it that they actually want to achieve? I think that would be interesting. I mean it in a slightly controversial way, but it'd be interesting to understand what their end game is, because the way things are evolving is not necessarily great. Now, for me as a lawyer, it could be very interesting because I do data litigation, but I always hope my clients don't need to go down the route of litigation. I try to help them to avoid it. And I think if regulators were more interested in exploring avenues for things to work, we could avoid a lot of this litigation. And I think that could lead to interesting avenues where maybe we can avoid having to have consent for everything indeed.
Thank you, Peter. Thank you very much again.
Thanks for having me. And then let me know if there's a third time.
Of course I will. Okay, that's all for today. Please follow the Masters of Privacy channel on LinkedIn if you want to find some interview transcripts, cheat sheets, and other useful resources and surprises every now and then. On top of that, episode notes and other feeds are available on mastersofprivacy.com. Thank you for listening.